What we're going to do first, as far as class today, is we're going to discuss the Second Amendment just generally first. And if you'll notice that, yes, Michaela.
Didn't you want to talk about some
Yes.
that pulled up?
Of course you were the person that remembered. Thank you. Um, uh, so yes, I did want to talk about an issue that has come up within our state itself. Before we get into the Second Amendment. So if anyone can tell me who remembers the issue in, I believe it's Stevens that you all hate so much. What was going on in that case? Anybody want to remind me?
Was Stevens the one where he was creating like media and selling it?
Yes, so this was the cat crushing videos, if you guys will recall the individuals. And we got into a discussion at that time on other Supreme Court cases that had followed it. And I specifically told you all about a Supreme Court case where the use of simulated images of children engaging in sexual acts was approved by the Supreme Court. And we talked kind of through the issue at that time. And I want to just remind you guys, like, that would have been before or while I was in law school, which would have been like to 26 in the 2010s. We'll just leave it that. It would have been in the 2010s. So it's been a minute, and technology has obviously moved since that time period, to the point now where we're not having issues of simulated images like that are just kind of, computer depictions of humans like Sims or something like that. We are fully in the era of AI. So we are now seeing images that aren't just simulated, but they are incredibly lifelike, and in some instances are almost identical to the individuals, or can be identical to the individuals they attempt to depict. So this week, does anyone know where I'm going with this? Anyone heard any news about this in Tennessee this week, other than the individuals I tagged on Instagram? I know those of you tagged on Instagram, you can chime in and talk to your classmates about what's happening in Tennessee this week.
Honestly, I'm not aware of anything, so it would be nice to know what you guys are talking about.
Yeah, for sure. Did anybody read the article that I posted on Instagram?
It was about like the AI stuff, and if I remember correctly, something about like sexual harassment towards women and children specifically.
Yes. Yes. So does anyone know who the Tennessee Three are? Okay, some people nodding. Do the people nodding want their points for today?
I don't
They
remember
were
their
three.
names.
Oh, you can get it, Taylor.
Well, I don't remember their names, but are you referring to the three that ended up getting like kicked out and then reestablished?
Correct. I am referring to the three individuals. What's my Insta though? So it's at Professor MK. Is it Webb or is it just W? At
Uh,
Professor MKW. That is my academic Insta. I
it's
believe.
MKW.
Yeah, at Professor MKW.
It was gun control protest, right? That they were
Hmm.
kicked out of, and then they got reinstated. And one of them was it? One of them is our representative or
Yes.
part of Memphis.
Yes. 100% correct.
Is
So
that
to
the same one that the one that is from Shelby County? Is he the one that ended up bringing like the infant-sized casket in there and then like caused an uproar?
That I don't know. I know. So there's two, and they're both named Justin, which is very confusing for a lot of people, and it's even more confusing for a lot of white people because they're both black men or men of color. Um, so white people are very much struggling to figure out the difference between these two. They're very different. One is Native American born. His Instagram handle is Brother Jones, and that's kind of how he prefers to identify. He is the one that introduced the legislation this week, but he is one of the three Tennessee members of legislature, including Gloria, Representative Gloria. Oh my goodness, my last name just left me. It starts with a K. But she's from Knoxville. and Justin, brother Jones, Justin Jones from Nashville, and then Justin Pearson from Memphis, who is our representative, were all the three individuals who were this time last year, removed from their positions or ousted, kicked out of their positions in the Tennessee State Legislature for violations of conduct. Meaning that they held and protested specifically gun control laws here in Tennessee, which ties into what we're moving into, obviously, into gun control in the Second Amendment. Yes, thank you so much. Taylor shared in the chat that Justin Jones, the same individual that I'm going to be talking about, if you want to click on the link, brought a infant-sized casket later to a different legislative meeting after being reinstated. So after he and his two fellow members of the House protested with individuals about gun control, which again, we're going to get into this week when we address the Second Amendment. But they also once they got reinstated, Representative Jones, specifically from Nashville, introduced legislation this week about the use of AI-generated images and depictions of child abuse, of child pornography, and of violence against women. And he makes a couple of interesting arguments about how this is different from things that we've seen ruled on in the past. So based on what we know, how do we think a potential law like this might be upheld or get struck down according to constitutional requirements of First Amendment and speech?
What was that acronym that the artistic, political, scientific? I'm forgetting one.
Yeah, LAPS, literary, artistic, political, scientific value. So first and foremost, we ask always if it has a prurient interest, right? Because this would be talking about issues of obscenity. So we know we're in the First Amendment, right? Everybody knows that. These are depictions, they're images, putting them out there. We're First Amendment territory. This is specifically the right to speak. This is part of considered speech, sharing your information. And if we know it's going to be a content-based regulation, we are looking at strict scrutiny. Typically, however, this category of speech is one that we would first discuss obscenity with. Is this obscene? Is it even covered by the First Amendment? Because if it's not, then we don't have to protect it. So let's do that breakdown. First and foremost, yes, that's exactly where the second part of this is going, Taylor. The first part, let's just address that. Would we consider AI images of child pornography, child abuse and neglect, or the abuse of women to appeal to the prurient interest? Michaela says yes. Yes, it would. Why would we typically consider this to appeal to the prurient interest?
Because doesn't like the whole, I don't know if it finds it like pleasurable or like kinky, but like society as a whole agrees upon it.
Society as a whole recognizes that it has some sort of sexual connotation, or an intimate connotation might be a better way of looking at it, especially if we're talking more about abuse against women and children. Those happen in intimate settings and situations, not necessarily always sexual ones. Of course, the biggest issue that Representative Jones is discussing is, of course, the issue of child abuse and sex trafficking and things like that. But overall, yes, that is the general answer. Yes, it does appeal to the prurient interest. So then we ask the second question, which Michaela already brought to our attention. Does it have literary, artistic, or scientific value? What do we think? No, Michaela says again. No, somebody wants to make me the argument. Why doesn't it have it? And remember from the last time, we had to answer the question of like specifically with abuse and neglect or things like that, that we weren't dealing with actual depictions. So, and the court had to say, when we have to deal with, this is a content regulation, we're applying strict scrutiny. Is this narrowly tailored to avoid the injury that we are supposing to be protecting? And remember, the court said last time, false images don't hurt any children. So what do we think of this law? And go ahead, Gracie.
Sorry. Can someone argue like scientific like research or like something? That's why they were doing it.
Wasn't necessarily why they were doing it, but the court held that there was some scientific or some value in it, in that since the law was enacted to attempt to kind of combat an issue that was very real, but provide, you know, a victimless way of providing an outlet for some people, and that the harm was that real children weren't being depicted. They weren't being, it wasn't the result of a real child being in that situation. What is the concern between what was computer generated ideas at the time and now AI? What's the difference? Or do you think that there will be one? Will the court find one? I'm still checking away over here, guys, so just keep that in mind.
I think that maybe this is kind of like far off, but I feel like the court and government as a whole is going to start worrying about the advancement of technology and when it starts to surpass us.
Right? Because this is artificial intelligence. This is only stuff that human brains can do. Or honestly, sometimes, and not even situations where human brains can do it. And thank you, Ben. Ben shared the article that's talking about the bill that Representative Jones proposed. So what is, does anybody else see if there's going to be a difference? Let's assume that the court takes up this case eventually, like they did with computer generated images of child pornography. Do we think that they're going to say same thing because there's no real children being depicted and there's no real harm? Or do we think that, you know, Taylor suggested, you know, that we've come a little bit farther as far as computer images are concerned, so maybe the court will look at it a little bit differently? And if so, what do you think, based on what we all know about AI so far, what is that concern?
I mean, logically, it would, like, if you're looking at cases that preceded it, you would expect them to say, no, it doesn't hurt anybody because it's not real. But I feel like it's changed a lot since those cases, especially when it deals with like child pornography.
What was one of the other things that you guys brought up when we talked about this? It's a specific argument that applies in a lot of constitutional situations. It has to do with where we draw the line.
Is it oh no, that's not that, never mind. I don't know what it is, but I'll know when I see it.
Oh, no, that's obscenity, but no. The slippery slope. So a lot of times in constitutional questions, because we're always trying to find where the line is, we're worried about at what point we're teetering down the slippery slope. So knowing that that is an argument that we frequently hear the justices talk about, especially with respect to First Amendment rights and what we do and do not allow someone to say, where, you know, especially in the realm of obscenity, do we think where this might fall on that issue or that general discussion that the court has? So what's true about AI that's not true about like previously computer generated images?
It's super realistic.
Hyper realistic, yes. Why is it, how does it allowed to be hyper realistic? How is it hyper realistic?
Because it learns from real things.
It learns from real images. It takes real images and tries to create the most lifelike. And we know that it tries to, and in many situations can almost identically create or alter images that were real photos. So we know that AI can be used to adjust real photos that were taken and then create depictions that didn't happen. So I don't know if any of you have even just watched like the Adobe AI commercials that are teaching people essentially how to like Photoshop their children into like these crazy, cool, magical realms, and they get to have fairy wings and they're in there with mushrooms. And it's like, look what AI can do for you and your kid in your photos. But it was using a real photo, right? So now knowing that difference between AI and yes, AI, Michaela's timing in, AI is terrifying. I agree. Gracie, go ahead.
I would say it's not really the picture, but have you seen like where AI has done the vocal like recordings and there's actually been like lawsuits from like
Yes.
people? Yeah.
Yes, about the use of the likeness of their voice. We consider our voice, and there's been a lot of intellectual property on image and likeness. So I don't know if any of you follow sports at all, but that's been a huge issue in the last several years because colleges have been using the news images and likenesses of their collegiate athletes, and that brings them buku money. If anyone hasn't known about Flau'jae, Angel Reese, and the rest of LSU and Caitlin Clark in Iowa, then you are just like light years behind the rest of us. So I'm sorry to catch you up. Okay. But yes, Taylor's pointing out, we can now use AI to have SpongeBob singing Kevin Gates. Did that really happen? Did the actor who voices SpongeBob really do that? And so now we have all these questions about, did it really happen or did AI create it? Yes, actually, that actually was what I was referencing, Michaela, of people creating AI images of Taylor Swift. So those are, so yes, for those of you who don't know, I am not a T-Swift. I'm not a Swiftie. Don't talk to me about this, generally speaking. But in this particular circumstance, Michaela, you make a great point, and I'm very glad that you brought it up because it is one of the reasons that Representative Jones particularly cited was that it's not just creating very false lifelike images. People were actually using AI to make explicit images of Taylor Swift. So they were using her face and other photos to then just like fill in the gaps. So if that's true for what we know about someone like Taylor Swift, whose image is easily Googleable, how true would that not be about any child that you just took a very normal photograph of and then scanned it? What would AI allow us to do with that?
I mean, I don't think AI really like knows the difference between like an adult and maybe like a child because it's like a computer. I mean, maybe to an extent, but like someone that's like 16 or 17, people could say that they look like a little bit younger, or they look 18, things like that. So
Absolutely.
the computer doesn't know that. And the computer also like, I guess doesn't have morals unless I don't know a lot about AI.
Right.
Goes into it, but like computers aren't human, so they don't have like the morals that we do to take that into account. So they're just gonna do the same thing that they did to Taylor Swift.
Yes, they just learn and they create what's asked of them. So what's stopping anyone from taking a completely benign photo of a child and having AI ask it to essentially do what it couldn't do without legally? And so the question then becomes, AI now is kind of a tool to accomplish child pornography without actually forcing the child to do so. And that's the sticky situation we're in with technology. The child didn't actually maybe experience it, but now, just like Taylor Swift issue, where explicit images of her exist online, and even though you can say, well, they're not real, they're going to get treated like real images, and they certainly are going to, affect her as if they were real images, and that's going to be even more true for anyone else, and who gets victimized in that way. So again, having that conversation now, where do we think the court might fall on that issue?
Well, my question is though, like, is there something the government could actually do when it's dealing with something like AI? Because it's a technology, so can they really control that?
Yes, we can absolutely control that. That's why Representative Jones has put a bill into Congress to control it. Anything that it's due to the Commerce Clause, we don't study that in this area of constitutional law because it doesn't typically help explain much that goes on in the criminal constitutional realm, but in this particular instance, it's kind of helpful. So I'll do a little bit of an explanation. So essentially, the Commerce Clause exists in the Constitution, and it says that the United States Supreme Court has jurisdiction over matters of constitutional or national import. And the way that we get to regulate a lot of business at the federal level is because of this very one specific clause called the Commerce Clause, which has to deal with interstate commerce. So any business that crosses state lines can be regulated by the federal government. Tell me a business that is not regulated, that does not cross state lines in today's day and age, keeping in mind that like even local businesses, like one of my favorite local stores is Stock and Bell. I can buy that anywhere around the globe, can I not? I can be stationed in Afghanistan if I was on tour and buy that and ship it to myself, could I not? So the federal government has very long reaches as far as what we can and can't control with respect to business. So because this would be some kind of venture that would cross state lines, the internet is all under the control of the federal government. With respect to like certain things, obviously certain things can be private, your certain aspects, but because the internet is a public domain and public space, the government can control it, regulate it, just like it can public property. Does that make sense? It's not because it is a public property, but it's just kind of because of the broad sweeping nature of the Commerce Clause and the fact that essentially all of this relates down to money, because we live in a late capitalistic hellscape. So back to the question though. Now, how do we think the court is gonna hang on, there was something else in the chat. Taylor also brought up the idea of a possible defamation suit. Absolutely. If someone is using your images to create a false image of you, so I don't know if any of you know the legal definition of defamation, but it's essentially that you make a statement, and we talked a little bit about this in First Amendment, so just to give you a refresher, when we talked about the MLK case, you make a statement that you knew was false or made with like reckless disregard to its truth. Would we say that it's defaming someone or to post images about them that weren't truthfully taken, that they also didn't consent to? That's a whole big issue. It's actually a crime to disseminate images of yourself or of anyone that they didn't consent to you sending. So it flies in the face of a lot of those laws that are already out there in protection. So if a child, again, completely benign photo is taken and then images of them that are rendered by AI are shared, that is a crime. And then two, we have to wonder if AI is going to, the use of AI to complete that crime is going to run any constitutional issues. And then two, how is the Constitution going to address things like Representative Jones' suggestion, which is that all of these should be deemed illegal given the harm posed to children and women depicted therein. Do we think precedent is going to rule the day, or do we think the court, like we've suggested, might look at a couple of other factors?
I believe.
No, you go ahead.
Oh,
go ahead, Lorena.
I believe, thank you, but I believe that the court would definitely look into it more. I don't think they would rule the same as they did with Stevenson, simply because it's like the points that we've hit, that it can kind of, create a rude awakening, and not solely for like child pornography, but also kind of just like your identity, identity theft, or it can also create excessive like a lot of like discomfort and like ruin your reputation. And then the thing, like for instance, like Taylor Swift situation where she has all this fame, and like of course everyone's gonna, I don't like her, but I mean I also don't have any issues with her, but she always still pops up on my end, whether I'm a Swiftie or not. So I definitely do agree that the court would kind of start looking into various areas.
Michaela, did you want to add anything else?
I agree. I was going to say, I hope that they would take other stuff into consideration.
I would generally tend to agree, especially remember we have a more conservative court than we did the first time that this case was heard. This court is definitely going to be more concerned about the protection of children. And I also think that there is a distinguishing feature between being able to use an actual likeness to create, or someone's actual photo to create explicit images, because that takes us back into like kind of a consensual situation where, if they had been in person, that person might not have or could not have consented to their clothing being removed, and if they had, that would still be a crime. So using a computer to essentially, I think, dismiss that process or avoid having to coerce someone, I think the court isn't going to take very kindly to. I think they're going to say this is it's actually worse than coercion or force, because it doesn't it's more sneaky and stealthily and doesn't require a person to be there. And so I think we will see that. What about AI First Amendment issues with the use of AI? I don't know, let's say on your school papers. Because I will tell you that the university is currently facing that issue and what we're supposed to do with it. So what do you think generally universities are going to say? But let's say a student, were to take this to court and say, I should be able to use AI. So it was a generator. I put the stuff into it. It just copied it out. It's not using anybody else's. It's just mine and my conversation essentially with AI. What do you think? How do you think that's going to play out in one, the academic situation? Put that to, and then two, potentially in a court situation when we invoke the concept of free speech.
I think one thing that needs to be taken into consideration is like the amount used. Like, is it 100% or did they use it for a small portion? Like how it came about and how much is actually in the paper that's generated.
And do you think that matters more for a court or more for the academic setting?
Academic setting.
Yeah.
I was just about to say that.
Yeah.
Mm-hmm.
Victoria, you have your hand up. Go ahead.
What I was gonna say is like, to add on to what Taylor said before, it should be taken into consideration, like how much, because I mean, if it's for like 5%, sometimes like it'll say it's plagiarized when you're using like quotes and stuff like that you're like quoting someone. So, in those cases, like that's where you should like look at the percentage and everything. But if it's 100% plagiarized, like your work, yeah, you might not be directly copying somebody else's work, but it's still supposed to be like your own intellectual thoughts, not AIs or a computer's. So I feel like it should be very much an academic kind of thing. Like it should stay in that zone. But I still think like schools should take that into account. And I feel like they would probably say like, I just feel like that wouldn't fly with them. Like saying that I didn't copy anybody else's work. You're still kind of not like using your own, I guess, intellectual knowledge to come up with the answer, which is what school is for. So it's kind of defeating the purpose,
And then I saw Josh, and then I think Gracie also said something, but maybe she put it in the chat. Go ahead.
I was looking at it more not in the sense of like how much credit or how much like ownership you have of it, but more of like whether when you're using AI, is it like disruptive, like or the context of how you're using it, is it obscene, does anyone else take offense to it, and
right,
like because obviously like you're putting the image out there into the AI, so it's coming from you, so that's where I was going with it, as more of like if you're using AI images, the target, the audience that you're going for, like you have to see like how people are going to perceive it as well.
Yeah, absolutely. And to add on the chat, Gracie says, way to use your resources. And then to Taylor, to everyone else, I've seen individuals marked BI because of speech pattern, particularly when individuals who are neurotypical or autistic are writing. It will also happen commonly in versions of academic writing, because frequently academics will change verb tense when they write. So I have personally ran a paper that I wrote at points in my life through an AI or checker, and it flagged it as AI, was not. So then that question goes back to the slippery slope of like, well, when are we going to know if it's real or not? And that's the thing the court is going to ultimately hang its hat on, is before we could know it was real or not. Now we can't. Lorena, go ahead.
So honestly, that's kind of what I was going to start.
Go ahead.
I feel like it depends on kind of like the content or exactly what the purpose behind it is. Like for instance, sometimes like, Grammarly, that technically is AI because it's correcting, your verb tense or adding commas and all. So like if someone's using it for that instant, kind of like, you know, correcting their grammatic errors, I wouldn't be like too opposed to it. Now also if someone's, let's say like, you know, trying to, they come up with the paragraph on their own, not using really anything more so their knowledge, and they want it to sound more academic or, you know, a little more smarter per se. So then if you're using it for that, I don't know, it would kind of, you have to look at like both aspects. Cause now if I am taking something from another like website and I'm simply just paraphrasing it, then yeah, that does bring up some concerns. So, and then like also the point where you like add on, like if it's someone who has like, you know, dyslexia or just another like intellectual disability, then if they're using it, you know, for their own like purposes or to do well, then it's kind of like who, you can't restrict certain people and then let other people slide with it. So I feel like you kind of have to look at both aspects. So, I know that's tricky. That one is definitely.
I think all this is great discussion. This is absolutely kind of how the university is addressing it kind of at higher levels, because the reality is, without even bringing up some of the very good points that you guys brought up, which is like people with dyslexia or people who have reading and writing learning disabilities, like would really benefit from having AI just to be able to type out some of their ideas and be able to help code switch it into smart people college language, right? Because it's not that they don't understand the concepts or they don't have anything meaningful to add. It's just that unfortunately institutions only prize language in a certain way. So what if there's a way to assist them to do that? And doesn't that create more equity? So that's a great conversation. I can tell you, even at the distance of majors. So like we don't want AI in the social sciences necessarily, because we don't want students to use it and, you know, use it to get ideas and research and essentially plagiarize all their papers. But then we have one, like we said, very real ideas about equity. And then we have to deal with the whole issues of majors like computer science. They have to have AI. They have to understand it. They have to be able to code for it. They have to be able to work with it. And that's not just computer science, but also like mathematics wants it. So they don't want a blanket AI policy that bans it, because there are very good things that could be used. So I think you guys have made some great points as far as like what the academic institution is going to do. I think I think, you know, a court case is going to follow suit. Let's just see what happens and see what the kind of context case will be. It may even just be that we have to kind of piecemeal, very much like we do with search and seizure law, as it develops. We will have an idea of where we're going to put it. Maybe it'll be in search and seizure law. This will probably be in First Amendment. And I would say that maybe the court's going to say you don't have the right to produce false images of someone else. So that's, I think, maybe what the court might ultimately come down on is, you know, these aren't real, they're fake, and we don't have a right to perpetuate fake images of someone else, unless it's very clear on there is fake and watermarked, almost like we would, you know, see with a political cartoon where people are rendering likenesses of individuals and then using it to make fun of them. I think we'll have to find something along those lines where people are allowed to recreate false images in a way that provides critique and doesn't squash speech, but in a way that also protects an individual's right to privacy of their own likeness. And that will obviously actually differ between whether it's somebody like Taylor Swift or whether it's somebody like Taylor McNevin here in our class. One of those people actually does have a higher level of privacy than the other, because one of those is a public figure. And so you have lower levels of privacy and expectations of privacy in your image and in the reproduction of your image than someone else does. So I wanted to just bring that to attention because it's super relevant. So that literally got proposed in Tennessee this week, or last week, I should say, now that we've started a new cycle, let's say. So that's going to be interesting to see if anyone even challenges that. I think we're going to see the ACLU maybe challenge it, which will be interesting because normally they don't challenge super liberal representatives, but they don't like anything that even looks like it might infringe on free speech. So we'll see if any of the civil litigators want to take up action against this particular one, or if maybe this is going to be finally when we all agree on. But if anything, if history tells us anything, that's not going to happen. So we'll see a court case at some point, and you'll remember this excellent class discussion that we had. All right, moving on now to Representative Jones's other big, I don't say big claim to fame. He's a brilliant individual by all accounts, but one of the reasons he made national news was about his particular thoughts on the rights of gun owners. So I'm going to share my screen and we're going to talk a little bit about the Second Amendment. Okay, I get that. So first and foremost, sorry about this. There we go. Hopefully you can all see that now. Second Amendment, unlike a lot of other amendments that we will discuss, like the Fourth, the Fifth, and the Sixth, which all have, and the First, which we already discussed, which have several rights enumerated, the Second Amendment is concerned with one and one only. And it specifically stated a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Period. That's it. That's all it says. It's one sentence, one of the shorter ones. Previously to the cases that you would have read, which is DC versus Heller and is it Chicago versus McDonald or McDonald versus Chicago? I can't remember. It's one of the ways. We didn't have a whole lot of cases on gun control and gun laws, and that was because of this case, Presser versus Illinois. I have it in bold here. Presser was decided in 1886. What is super important about the decision of this being made in 1866?
That was a really long time ago.
Yes, first and foremost, it was a really fucking long time ago. What else was significant about the period of 1886?
It was right around the Civil War.
Correct. We are just out of Reconstruction. The Civil War has ended in 1865. This is about 20 years later, and keep in mind, court cases take to the Supreme Court at least 5 years at that time, probably, to get to the court. So that case didn't necessarily start overnight in 1886. It probably started before then. Following into Reconstruction, as Reconstruction was continuing to develop, and as we were headed into the 19th century, what was also taking root? The big historical movement that we're really proud of in this country. Makes us better than all the other ones.
Movement?
Not civil rights, no. We should be proud of that. We're
So
actually more
60s. Yeah.
We're actually more proud of the Industrial Revolution. That's what I was hitting at. So at 1886, we're heading into the period of Industrial Revolution. And the reason that that specific context is important is because that movement saw a lot of, or was one of the biggest reasons that we saw a lot of immigration at that time, immigration to the United States of individuals who were from Germany, who were from basically it's non-ethnic whites is how we can phrase this. So anyone from Ireland, people from Scotland, people from Germany, Dutch individuals were all kind of immigrating to the United States en masse in search of better economic opportunities promised by individuals does anybody watch The Gilded Age on HBO Max? But promised by those guys that are running the show, the Vanderbilts, the Roosevelts, the Kennedys, the Carnegies, the Jay Goulds, all those individuals of the world who were making lots and lots of money and were hiring lots and lots of immigrants to come and do work on railroads essentially around this time, connecting the country. So that's the kind of social historical background for Presser. This is also a time period in which we saw a lot of westward expansion, again, via the railroads. That's a very important thing because I don't know if many of you know, but a lot of times the growth of the railroads and then the working conditions for individuals who were working on railroads were constant sources of local frustration, local protests, and there were constant kind of issues with the workers and the giant bajillionaires that were in New York or in California or wherever they were at the time. Again, if any of you watched The Gilded Age, this is referenced in that one. I just finished it because I got sick of watching Bridgerton for like the 400th time. So Presser versus Illinois comes along in 1886. And the facts of this case is that the defendant was a member of a citizen militia group, which were very common in the West at the time. Again, remember that the West at this time was expanding faster than essentially the court or law could keep up with. There was a lot of vigilantism. So as fast as they could establish shanty towns to try to set up new and developing areas, courts weren't really keeping up with all of that. And so who was going to enforce the law? Vigilantes. And this was a defendant who was a member of such a group, comprised of specifically and only armed German workers who were associated with the Socialist Labor Party. How dare they in this capitalistic state do that? I make that joke because I do think it is a relevant fact of why we ultimately ended up with Presser as the decision that we did. And Presser was charged with unlawfully belonging to and participating in parades and drills with an unauthorized body of men with arms who associated together as a military company without a license from the governor or being part of the regular organized militia. So there was a law that said essentially at the time, if you are not part of the militia or the government hasn't given you a special license to gather and essentially train as a military unit, aka we haven't given you a police department license, then you can't conduct these parades and drills with guns. Can't do it. Presser argued, bullshit, this is my Second Amendment right, and I have the right to bear arms. That is what it means. And just because you have this state statute, I don't need your license. I'm allowed to do this. Again, 1886, the court wrote, which I think is a super important quote, which is why I have it in here directly, the right voluntarily to associate together as military company or organization with arms without an act of Congress of law of the state authorizing the same is not an attribute of national citizenship. What does that mean? Anybody want to tell me what that fancy law sentence means in normal people English? Want to code switch that out of old white man language for me? Anybody? Go ahead, Andy.
Okay, I'm gonna try my best.
That's all right. I'll put you back in the trust nest if you fall out.
Okay, I think it means basically that if you and a group of people come together, like under the guise of a military company or organization, armed organization, without a law stating that you can do so, your acts don't really fall under the Second Amendment as protected as a part of like citizenship, as like your right to bear arms.
100%, that's right. Victoria, go ahead.
I was gonna say at the end, it kind of sounds like they're telling them like they're not from here, like of their national citizenship. So they're trying to also say like that's not really your right because like you're not an American citizen.
Excellent. Those two in combination. Love that. Andy gets at exactly what the court is saying, which is like, unless we approved it, no, you don't get to do this. Period. That's our job, is kind of what that sentence says. And I think Victoria's point absolutely hits on a little bit of why we see this result in Presser versus why we see a different result later when we're going to talk about DC versus Heller and Chicago. This person was not a citizen. He was a German an immigrant associated with a labor party. The court went on to rule that these are under the unique, specifically paramilitary organizations are unique and under the distinct control of the government of every country. So they're saying, hey, this isn't a unique to us thing, where it's not just a United States thing. every country has one military. Not every country does not let every local organization develop their own military. No, this is not unique to us. We give the right to make the military. And cannot be claimed as a right independent of law. So they said, no, that's our job. Goes on to say, specifically wrote, quote, under our political system, they are subject to the regulation and control of the state and federal governments, acting in due regard with their respective prerogatives and powers. Now I'm going to just go ahead and tell you what that means in normal language. It says, we are the people in the social contract that are entrusted with, or we are the people in the social contract that keep you safe. That's our job. That's not your job. Your job is just to help and support in that process, not to actually go around running renegade and doing the safety. We do the safety. Next, the Constitution and laws of the United States will be searched in vain for any support of the view that these privileges and immunities of the citizens are independent of specific legislation on the subject. So they're literally saying, you won't find another place to reference the fact that you are entitled to own a gun and operate as a paramilitary organization anywhere else, or even a reference to it anywhere else in any of our written documents, because it doesn't exist. That's what the court is saying. So again, in other words, the court wrote in 1886 that the United States did not contain, or the Constitution did not contain, or even suggest that the right to keep and bear arms existed independent of the state or federal military. This is the court saying they are together. To bear arms and to operate military are the state's powers to control and regulate. As you're reading our next, or as you've already read, what we read for this week directly contradicts that. So in 1886, this was the law of the land. There is no such thing as the right to bear arms that does not connect to the federal government's right to regulate and control the militia. And if you look at the writing, you will see that it starts with a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. All of that is in there. And so the court is saying, yep, all of that is what you need. You don't have it, we have it. So we know that the first case we have for this week is DC versus, I think DC was first. I hope it is first because it's the federal one. So somebody tell me about the facts of that case. Taylor, go ahead.
Was kind of wanting to go back for like just a split second. Could
Yeah,
we
go
not
ahead.
make the argument, because you had mentioned briefly, like we have this in place to protect the citizens, yada yada. Can we not make the argument, okay, well, you're not doing your job as the military, so we have to take it into our hands?
That could be the argument that we made. That is not the argument that Presser made. Presser made that he had a right and that this infringed on his right. And the court's not, remember, going to go out necessarily and give themselves more or let people know that there are more areas for leeway than they might have otherwise. So they're not going to be like, hey, well, if you just argued that the government wasn't doing their job, we probably would have let you. They're not going to tell anybody that in a legal opinion. Now, if they had made that argument, maybe they would have said something differently, but he didn't make that argument. And also, I don't think they would have said anything differently. I think they probably still would have said, like, we disagree. We disagree. We're not doing our job. Just because you don't like the way you're doing your job, that's not the way to go about it, is to form an unauthorized paramilitary organization. You have the right to free speech and free assembly. You should petition your government or protest. That's probably what they would say, in my opinion. It shows McDonald Chicago versus is on the first module. That's totally fine. We will be looking at McDonald. Heller and McDonald essentially rule the same thing. They cannot be disentangled. So essentially, tell me what's happening in the case that you had to read. The first case. Go ahead, John.
The issue, oh, sorry.
Oh, so which one are we going to talk about first, Heller or McDonald?
Have you all read both of them?
I have.
I'm seeing a lot of head nodding. Okay, so let's talk about Heller first, because if I'm not mistaken, Heller comes first. Yes, it does. Thank you, Andy.
Okay. So
it
with
comes
Heller,
first.
it was,
Yeah.
oh, sorry.
Go ahead.
In DC, they had an ordinance that any firearms that you had in your house had to be unloaded and basically locked away or have a trigger guard on them.
Mm-hmm.
And they were arguing that kind of went against their rights.
Yes. So an important fact and why DC and Heller or DC and Heller and then City of Chicago versus McDonald are treated as two different cases, and they were actually kind of companion cases. They came 1 year apart. Where is DC? Under what control is DC?
Federal.
Federal control. So that's the important. That's literally the only fact that kind of distinguishes the DC and Heller case from the City of Chicago versus, and that's why the 14th Amendment gets implicated in the McDonald case, but not here in the Heller case, and that is because Heller involves the federal government. DC is under control of federal government. And they made an ordinance that essentially said in the 10 square miles of DC that you cannot have a handgun, even in your own home. It has to be fully unloaded and locked away. What happened? What happened? Go ahead, Lorena.
So he was a like special police officer in which he was like authorized and allowed to carry a handgun while on duty. And if I'm not mistaken, he had applied to be able to get the license, but he was denied.
Yes. So John is asking in the chat additional question. Is it handguns? It was all firearms. It might have been all firearms. I'm pretty sure that the next one, Chicago, was just about handguns. But I'm going to be honest, sometimes I get handguns and all firearms. I'm not saying confused. I know that there are many differences between lots of guns. I just lump them all into the same category because to me, they're giant killing machines, no matter what size they are. So, and most of the time, legally speaking, it doesn't super matter. There are some obviously restrictions to that. Most people generally think that AR-15s and those types of weapons are not necessarily civilian weapons, but most of the time we're talking about firearms or handguns. Sorry, they're all firearms. See what I mean? And also, I don't know why so many of them are named after random body parts. Handgun, firearm. What are we talking? Stop doing this. It's confusing. Anyway, my own soapbox. So yes, the individual was an individual who's actually employed with the federal government, and he applied for a special license to be able to do such as a police officer, and he was denied. And so he took that to court and said that this was a violation of his Second Amendment right to own a gun. What did the lower court have to say? I will also note that it's of a particular importance that the lower court that heard this was the DC Appellate Court. And that is because a lot of Supreme Court justices will serve on the DC Circuit Court before they are appointed to the Supreme Court. It's a very close pipeline. They literally work in the same 5 square mile radius. People who are at the DC District Court and the Supreme Court can take a 5-minute train ride to be close to each other. So it's not, it is actually, go ahead, Michaela.
The district court dismissed it, but the DC appellate court said that based on rights to self-defense, the Second Amendment protected the right to keep the loaded firearms in the home.
Yes, perfect procedural explanation. So the district court originally said, get out of here with that mess. No, Presser versus Illinois has been precedent for 150 years. Nope, dismissed. I don't want to hear this claim. And he appealed the dismissal of that claim. And the appellate court in DC, which is that court I was talking about, because again, it's an appellate court that's going to go to the Supreme Court right next to the Supreme Court. So it's essentially hey, we're just going to ask you guys over there what you might do with it. A lot of times under the radar, those kinds of things happen. Again, they're all in the same city. They see each other. They all do the same job. We're all humans. We can't separate the fact that that is reality. So in kind of signaling what the Supreme Court's actually going to do, the DC appellate court says, no, we do agree. There is a Second Amendment right. And so, of course, the state takes issue at that point and says they're going to appeal, and we get to the Supreme Court. What does the Supreme Court say about a Second Amendment right in this case?
They agreed with the appellate court.
Tell me why. Oh, John, to go back, it was illegal unregistered handguns. So it was. And prohibited registered handguns for some reason. I have that note, so it was handguns to answer that question.
The Supreme Court said that like the definition of militia was not like someone having a handgun in their home was not conducive with trying to form a militia or trying to make a group that would serve as like a military-esque group.
Exactly. So one of the 2 points I have is that the court spends a lot of time defining 2 particular words, or they use 2 particular words and focus on them for a lot of the decision. And first and foremost is the concept of a militia, and what did the founders mean by a militia? Because remember, who writes this opinion?
Was it Scalia?
Mm-hmm. Justice Scalia writes this opinion. What do we know about Justice Scalia?
He's very conservative.
He is conservative. What does that mean for his constitutional interpretation?
He's going to do
only
it
sees-
exactly how it was written.
Somebody else said it too, Michaela, and then who else had theirs?
I said he only sees like the 4 pages of the 4
Yes. Oh
sides
my
of the paper.
gosh, you guys are doing such a good job. So he's only going to look at the 4 corners of the Constitution. He's not going to look outside. And if he is, he's going to look to the time period, like Michaela said, what the founders intended. What did they mean when they said militia? That is what he's looking at. Excellent. He is an originalist interpretation. And then the reason that I want to focus on this is because next we're skipping the Third Amendment because it has absolutely no relevance in modern America. So we're going right to the Fourth. And when we get to the Fourth, I think you guys are going to be pretty surprised to see that Justice Scalia authors a fair number of pretty liberal opinions. And you're going to think, what in the hell has happened? And I want you to remember that, again, Justice Scalia is concerned with the 4 corners of the document and what the founders would have wanted. So yes, we think of him as a conservative, i.e. Republican, the way we think of it now, person who, hates abortion, doesn't think women should have rights, thinks women are still property, children don't have any rights. We think of him along those lines, and that's how we have this perception of him. But his doctrine, what he prescribed to as a legal scholar, was based on a very specific kind of interpretation, which is originalism, the 4 corners of the document, like we talked about, and originalist interpretation. So to any extent that he's going outside the 4 corners, he's only going to be trying to concern himself with understanding what those people who wrote the document would have meant, not what they would have meant in current times. So he focuses a lot on militia. And like he says, a militia in 1775. What was that? Why were those needed?
Because we were technically still like an extension of England.
Absolutely. And if we didn't have some version of like those things that allowed militias at the time in the developing colonies, we would have been running afoul of the Constitution all the time. So that's kind of his point. Like the idea behind what militia meant at the time was for us to exist, to be able to defend ourselves. That's what it was. Small militiamen could get together to defend themselves. And that was the original idea of including the word militia. Not necessarily that we meant only the military, but that people should be able to act in self-defense. So tell me what else? You guys are doing great. I'm so proud of you.
Actually, I have a question.
Yeah, go ahead,
Okay,
Benicia.
so like right now, like you can carry a firearm without a permit or a license, but you can't have it loaded. But my question is, if they don't want us to have it loaded, how are we supposed to like act out of self-defense? Like we're not gonna have time to load the gun and then act like I don't understand that. Like why would they want it to be like that?
So my answer to this question kind of is going to explain the difference of what it means to be a legal fact and what it means to be true. So a lot of times we have the idea that like once a jury renders a verdict that is guilty, that becomes what we know as a legal fact, that MK was found guilty of murder. Taylor says because the government doesn't have to make sense to everyone else. Essentially, yes, that's the answer to this question. But that's because we have legal facts and then things that are true. So there could be a situation in which I'm found guilty for the murder of Dr. McCuddy. And it becomes legal fact. It is true. If I maintain my innocence and I say that did not happen, our dogs attacked him and brutally ripped him apart. I had nothing to do with it. And that's my defense, but I lose at trial. It still becomes legal fact that I killed my husband. Does that make it true? No, it doesn't. It doesn't make it true. So that's kind of this distinction with, or when we talked about it in 3510, it's the difference between, it almost sounded like he needs a warning. He doesn't. He knows how much danger he's in at any given time. Normally he's home and he would be hearing me. Today is like the one day he decided he wanted to go to the office instead. I don't know, whatever. So it's the difference between like a legal fact and reality, or like kind of what we want to believe the law exists, or the law that exists, and reality. So in the law, we want to pretend and give the idea that we're allowing citizens to defend themselves by saying like, absolutely, we'll give you a right to bear arms, and you can carry all the time. But you can't carry loaded. And you're like, okay, well, if the idea is defense, then I should be able to do that. Team Padfoot. Padfoot would never bite Daddy. It's only going to be Luna or Leia. Anyway, but you could keep ammunition on you, load, and then fully be ready. That's the idea. And since that idea can exist, and then you would theoretically be able to still be within the bounds of the law and self-defend yourself, since those are both like legally true, even though we know realistically that's not life, it's not going to happen. So a couple of things going on in the chat that I want to address. So basically nobody truly knows if the gun is loaded besides the person who actually had it. Correct. Walking around, can you tell the difference? Most of you, John, I think you're probably the only one that can answer this question that could answer it, or anyone who has a lot of other familiarity with weapons, but I know John does, could not tell if a weapon was loaded or not just looking at it. Can any of you? I can't. My husband has a gun and several of them. I could not tell you if any of them are loaded at any given time. Doesn't exist. It's not that it doesn't happen, it's just doesn't. So just there. But in theory, you could also keep ammo on you at a different place, and then you could assemble those things together for the purposes of your self-defense. So that is the legal realm that they want you to exist in. But we all know that that's not the world that we live in, because as Benicia correctly pointed out, you do not have the ability on most of those situations to take time to load the weapon so that you can fall within the realm of the law. Taylor, go ahead.
So they want us to have the knowledge of how to do this, but they don't want to require the training to do so.
Yes. Bingo. Now you've just described pretty much every government problem that exists. You get to have the knowledge because we believe in freedom of speech and we believe in free access of that information. That does not mean you get to act freely. So the law summed up in like 2 minutes with MK. That's my podcast. But no, there's another really, really, really important militia is something Scalia focuses on, but there's another really important phrase or word that Scalia uses to describe certain words in the Second Amendment. Does anyone know what it is? It starts with a P.
The prefatory clause.
Prefatory clause. Yes, Andy, 100%. Tell me about, if you can't tell me about the prefatory clause and you would like somebody else to chime in, that's fine. But if you can, please do tell me what does he mean by prefatory clause? Translate
Okay,
that from old white man language to normal people language to me.
Okay. I had to read his opinion to figure it out because it wasn't really in the case. But it's basically just the interpretation of the wording of the amendment. So
yeah.
He focuses a lot on like the interpretation of organizing versus building a militia, because those are like two separate things when it comes to like a militia. Like organizing is separate from building a militia.
Yes.
So yeah.
What about the prefatory language? Someone tell me more about that. What does it mean to be prefatory language? What's the preface of a book? You open a book, there's a preface. What's in the preface?
It's like an introduction.
Yeah, it's like an intro. Somebody else unmuted themselves. Go ahead. Okay, preface is like an introduction. If you're going through your textbook, or even a lot of times fiction books, you'll have a preface that kind of introduces you to the concepts that are going to be used in the book, or just kind of generally spells it out for you and says like, hey, this is what this book's going to be about, or this is what it's going to happen. So Justice Scalia says that a certain phrase in the Second Amendment is prefatory language. And what is that phrase? John, go ahead.
Is it the part about the right to keep and bear arms?
No, he says that's the important part.
Oh.
What is the prefatory part then?
Is it the part about the militia?
Yes. So kind of going back, let me go back to the share the screen so we can look at the amendment itself. Jumping off, going back. Look at the amendment itself. If you'll notice, all of this part comes before, or comes with a series of commas. This is why people hate lawyers. The placement of a comma in English language before a sentence typically dictates an introductory phrase. So Scalia is saying that this what I have highlighted, a well-regulated militia being necessary to the security of a free state, is all just an introductory phrase. It has no real meaning. It's just the preface of the book. Thoughts on that? Keeping in mind, Scalia is an originalist and a four corners of a document individual.
I mean, I think it just, to me, when I read that, I think about how the right to bear arms for like citizens wouldn't be secure without a well-regulated militia or a military of some sort.
So does that, in your mind, mean that then the right to keep and bear arms is necessarily connected to the military and the state of control, or does it mean that it's just that was just what they meant at the time? It doesn't mean anything now.
I mean, I would think it's still connected. Yeah. That it still has bearing today.
So in a traditional originalist argument or four corners argument, we assume, and this is actually constitutional law as well, and this is actually something Scalia himself has written on, which is what makes this opinion just absolutely bonkers, is that we assume that if the founders included it and thought to include it, that they meant it. We don't assume that anything is what's called perfunctory, meaning it's just there. That's what perfunctory means. Like your appendix. Your appendix is a perfunctory organ. It doesn't need to be there. And actually, if it explodes, the worst that can happen is the infection takes over you. Then you could die. But if your appendix explodes or goes wrong, you can have it removed and safely exist for the rest of your life without needing it. And originalist interpretations of the Constitution never say that anything is perfunctory language. They assume that everything the founders included had an important message, and we needed to recognize that. And if we don't, then we're ignoring the original intent of the words. So, since Scalia has called this an introduction or prefatory language, how do we rectify those two things? In the chat, tinfoil hat vibes. Very that. Very that. How would you? If you're an originalist, how can you then say all of this is prefatory, introductory language? It has no meaning currently on what this right means. Those of you who have your cameras on are staring at me with a bit of a blank face. And I think that's an accurate answer, honestly, because you really can't. And that's kind of my point. It's a trick question. If you are making the originalist argument, go ahead, John.
Thought it's like an incomplete thought, so I I guess this is the trust nest situation again.
Yes, Benicia says, can you even really do that? Yes, but go ahead, trust nest.
Um, so I guess I'm trying to figure out, like, thinking back to what their state of mind would have been, having just come out of the Revolutionary War, wouldn't their idea of what a militia is be a little bit different than what we consider one? I mean, even
Yes.
not 20, 30 years later. So why would that phrase not be important?
Yes, exactly. So that is how you can see that at times, I've told you, typically we say like justices are conservative, originalist interpretations, or they take a liberal interpretations until it doesn't benefit them any longer. And that's where the swing people go. That Justice Breyer, he's there all the time. That's why we don't even know what his doctrine is. Is it liberal? Is it conservative? It's whatever it is that helps Justice Breyer reach the decision that Justice Breyer thinks is correct, which is actually what we wanted the Supreme Court to do anyway. We wanted them to do that. We didn't want them to so starkly align that we could always predict what they were going to do. But yes, even in 1886, the different idea of a militia was different than that was 100 years after the original Constitution and Bill of Rights was written. It's a full 100 years. So yes, we're only like 20 years removed from the Civil War and the idea of like a militia, but like did the Union consider the Confederate Army to be a recognized militia, or did they consider it to be a band of treasonous individuals that later were punished?
A band of treasonous individuals that were later punished.
Weren't they? I mean, in the South, we didn't punish them. We put statues of them up. But in the North, do you see that?
No.
And how are they referenced in history books? Are they referenced as military? I mean, again, it depends on which school you went to. In my school, some of them were listed. Some of them were listed as, these brave heroes. But generally speaking, we don't think of them that way anymore, do we?
Mm-hmm.
They're treasonous individuals. They existed. They operated a militia outside of government control, completely separated us as a union, and then we had to come in and crack down on them. We, being the North, come in, crack down on them, and fully build Reconstruction, have a full Civil War 100 years later because they operated a militia outside of the one that we gave them the license to operate. So did we actually not just deal with this in the Civil War when Presser was decided? So of course Presser is going to say, nope, no more of this. We just had a fucking Civil War. We're not about to have these renegade militias anymore. And instead, we've lost sight. We don't have any of those issues for 150 years. And then we come back, and now an originalist interpreting what he says is the framers' intent says that the well-regulated militia necessary to the security of a free state means nothing with respect to the right to keep and bear arms. And just to point out some of the things that were said in the chat during that time, some of those were along the lines of, how could you do that? Or I don't think you're as conservative as you quite thought you were. Liked that comment. That's funny, Victoria. But how would you rectify that? Can you? Because if you can, I'm very interested to hear the argument. I've read Heller many, many times. I discussed it ad nauseum in my constitutional law class in law school, and have discussed issues of constitutional Second Amendment with respect to whether felons can have the right to possess a firearm throughout my entire career. So I haven't been able to yet think of it. Just sitting here, can anyone think of like, how would I, if I was going to make this argument, how would I do it? What brain hurdles are you going to jump through?
I'm sorry, do you mind repeating like what argument you're trying to make? Or
how can you rectify Scalia's comment that the first 10 or so words is anyone could fight for the right amount of money. For the first 10 or so words is a prefatory language, meaning it doesn't bear anything. It's just an introduction, and it doesn't hold any meaning to the right to bear arms itself. Even though he generally supports an originalist interpretation, which says we give all full faith and meaning to each word presented in the Constitution, and we don't assume anything is meaningless. So, and to elaborate, there have been times where the Supreme Court, in litigating other areas of constitutional law, decided an entire branch of constitutional law, specifically in Commerce Clause, by where a comma was placed. So knowing that where a comma has been placed, it has issues of determining what kind of things a contract has or things like that. How would you if you were Justice Scalia says, yep, this checks out. I can stick to my originalist interpretation and still hold that this 10 words are just an introduction and don't mean anything.
You could start going down the avenue that there's a big difference between private citizens and people that are in the military or militia, or I mean that's kind of shaky, but it's the best thing I could think of.
That's pretty good for, I mean, the first shot. Way to go. Way to jump out of the trust nest and fly, Michaela. Anybody else? All right, that's actually where I want to leave you for today. I want you, between now and the next time we see each other, to try to come up with how Scalia, or how you think Scalia, or anybody, how you want to argue that those things can coexist. It's just an introductory language, but everything in the Constitution has meaning. And I want you to think on that, because we'll discuss McDonald for next time and city versus McDonald. Go ahead and be prepared to discuss the next one as well, or just generally we'll talk and get introduced to the Fourth Amendment, because I think I'm going to add a reading there on a particular case I think you guys will like. So we'll end there for today. Next time, let's start and see if anyone can solve Scalia's head scratcher. All right. Thank you guys. You are all free to go, and I will see you on Wednesday.
Sounds good. Thank you. Have a good one.
Yes, have a good one.